Okay, thank you everybody. And my topic is the change the battery. Okay, all right. My topic is globalization of corporate governance. It is on both soft law and hard law. Like the carrot and the stick, we always need to depend on our two legs, two hands, two wings to fly. So when we focus on the significance of the increasing significance of hard law, we should ignore the value of soft law. However, the terms of soft law, hard law, even the law are very controversial. So soft law is also the law too. But how to defend the law? In my opinion, for the purpose of our discussion, maybe I think a broader interpretation of law is necessary and useful. So internal law, deeply rooted in a market, is important, is a part of the law, is a part of the source of the law. The external law made by the legislature, made by the judges, are the law, but not the whole picture of the law. And I will explain why the internal law, made by the market parties should be considered as a law. And actually, soft law could take the form of internal law or take the form of the hard law. Actually, the soft law is not so soft as we may think. For example, a Chinese consumer bought a box of tea from an airport tea shop for 1,668 yuan. But he noticed a promise made by the shop. If I fraud you, if I cheat you, if the tea is not so genuine as I promised at the top quality, I'll pay you 10,000 times of the price. As a result, consumer bought the tea, and after testing, it is proved that the tea is not so good as the shop promised. So he decided to take legal action against the tea shop, whether 10,000 times of punitive damage is illegal. The shop said it's illegal. Although I made that promise, but it's valid the 3 times of punitive damage of consumer protection law. So the journalist, came to me, whether it's legal or not. I said, absolutely legal, lawful, and enforceable. Of course, maybe the court would have some discretion to decrease the punitive damage a little bit. So anyway, the soft law is not so soft as you may think. And also, I think it's important to realize that the global financial crisis or the scandal of the corporate governance collapse actually, are not, made possible by the regulatory failure. Actually, it's made possible mainly by the corporate governance failure. So for the legislators and the decision makers, they should not repeat the mistake. The government should not pay the bill for the fault, for the mistake made by the companies, made by the controlling shareholders, made by the wrongful insiders. Actually, when China experiences the turmoil of the Chinese stock market last summer, the government, inject, almost 2 trillion renminbi. But many, stock investors has not benefited from it. Where's the money? So I think we could focus on the corporate governance, which, should not, be ignored by the decision maker, and we should not shift the liability from the wrongdoers to the taxpayers. Too big to fail, but also means too big to fail. So we actually paid a great price for the crisis of the stock market last year. So I think we should focus on the corporate governance itself instead of the public powers. And also, the triple requirements of good corporate governance include good people, gentlemen, gentle lady, like everybody here. We need good institutional arrangements, including soft law and hard law. We also need a good governance culture. That is very difficult to change, but it really is very rewarding if we focus on it. And I would like to say both soft law and hard law are equally important, but not identical. The soft law, are guaranteed by the consciousness of every person, guaranteed by the public opinion, guaranteed by the market. And the hard law, guaranteed by the public powers, by the prison. But they're equally important, but maybe not identical or the same. And actually, the hard law, soft law, interact each other. So there's some hybrid between the soft law and the hard law. So even you could find a lot of hard law rules in the hard law, in the public law, or in the private law. And of course, you could also find many hard rules in the soft law. For example, the good faith principle criticized by Kant sometimes have been used by Chinese court to hear the case, to make the decision, because the court could not find any other applicable legal rules. So they think you're not honest enough, so you have to pay the damage suffered by another contracting party. And we also create a lot of obligations arising from the principle of good faith. Obligations prior to the including of the contract, or even in the process of the fulfillment of the contract, or even post to the fulfillment of the contract. And market has eyes. Of course, law has teeth. I always have some double things. And private law and public law are different in terms of soft and hard nature. But for the consumers and investors, they have become more and more powerful in China because of the help of the internet. If a hotel, has a scandal of, inconvenience to the safety of consumers, many consumers will boycott the hotel. A female customer entered into a hotel in Beijing. Actually, that's a very economic and very cheap hotel. And somebody, strange person, try to take her to somewhere. But the waiters are not very friendly, so they did not help her. But another customer helped her out. So when this scandal was released on the Weibo or WeChat, many consumers are angry. And also, the public opinion are very, very important for the reputation of the company. However, as the presentation made by Dr. Huang, Robert Huang, some audience asked him a question, whether the social responsibility information, could be held, seriously if there's some misleading or material omission in it. I do think there's some legal consequences, at least at two levels. First is the consumer's claim against the fraudulent practice. You told the public you treated consumers very well, but in reality, that is quite different, another issue. That also could trigger the unfair competition. Your competitors may sue you because you use the misleading CSR report to gain unfair comparative competition advantage. So I could request the government to punish you, and also I could request the compensation from the court. So I think there are some values of enabling soft law rules. For example, Article 12 of company law is very helpful. I was invited by a telecommunication company to attend a workshop several days later, and the first instance court used the CSR general principle to order the defendant telecommunication company to pay for the loss suffered by the telecommunication consumers because of the cheat by some bad people. They think the plaintiff believe that the telecommunication companies violate your social responsibility to avoid consumers. You have not guaranteed my telecommunication safety. So the bad people, using the telephone number, not for my single case, maybe could cheat many people. So the telecommunication company could have the big data. So with the big data about the bad people in man, you should remind your customers by the text or message to our cell phones. So the court said, okay, anyway, the plaintiff should be responsible for your own damage for 80%, but defendant should be liable for 20%. So based on corporate social responsibility. And the telecommunication company said, no, it's only a moral obligation, not a legal obligation. But as the first person in China to study the corporate social responsibility in 1996, I think the Article 12, is a general principle. It is, include both moral requirement and legal obligation, which is further, elaborated or clarified in other special legislation. And of course, there is some initiative on the legislation on corporate social responsibility in 2014. So the State Asset Management Commission requested me to take responsibility to do the research on the proposal draft of the corporate social responsibility. So we will focus on something which could not be dealt with by the environmental law, consumer law, or employment law. For example, when CSR is introduced into corporate governance, there are more dangers with the insiders because traditionally, the management could be held accountable by their shareholders. However, when the stakeholders, the non-shareholder constituencies, step in the corporate governance platform, the management would argue, okay, I do this for the non-shareholder constituencies. So I'm justified, I'm legal, I'm moral. So I request the court to dismiss the plaintiff shareholders' request. But even I would like to defend against the non-shareholder constituencies. I will tell you, I would like to do this, to advance the interests of shareholders. So the management could use, both CSR and shareholder primacy to defend against different groups of people, depending on different litigations. So I think the Chinese legislation on CSR will be able to solve this dilemma of the issue of divided loyalty or one servant, for two masters. It's very for you to serve only one master, but if you serve two, conflicting masters, you really run into trouble. And we should offer some safe harbor rules for the management who face this kind of confusion. And also the government facilitation or even fulfillment is very important, like the government procurement opportunities favorable financial loans and favorable terms of interest. Government criticism is also very important, like anti-BEPS initiatives and anti-corruption policies. So in addition to the CSR and the shareholder primacy dilemma, also the anti-takeover strategy has triggered a lot of debates in China. In the real estate, Vanke company, would like to invite Chinese local state firms, Shenzhen Metro, to enter as a new investor, but the company has not fulfilled the process of the board of directors. So the current shareholder criticized the management of the Vanke real estate company. Why didn't submit this issue to the board of directors? He said, we already had informal communication with the shareholder. So, but I think the hard law could, draw a line for the board of directors, to use the anti-takeover strategies to advance their selfish interests. For of course, mandatory hard law rules are also very important, especially the ranking of different priorities of the stakeholders. I think first, the basic fundamental human rights are the first priority. Second, the stakeholders who will be considered as a public interest. The third priority will be the individual rights of the other shareholders. And I think soft and hard law need to work together. For example, dividend policy. Some of these companies in China do not declare dividends, even though they're very profitable. In my opinion, if they do not, declare the dividends to their shareholders, the future legislature should step in. In my opinion, at least 1/3 of the profits should be distributed to the shareholders. If the company is not profitable, I think a mandatory automatic audit process should be initiated to investigate why the company is not profitable. So the accountability of the insiders or management will be taken. Of course, the corporate autonomy regulations, constitutions, bylaws, shareholder agreements, and good corporate governance policies as the soft law should be strengthened. And also the listed companies association and stock exchange should be encouraged. Hard law needs to be globalized based on the commonalities between and among the different states. So my short conclusion is that first, we should encourage the reasonable autonomy of the market players. Second, the self-regulatory bodies should be given to the second priority. The third priority will be given to the government. I don't think the government regulation should be given to the first priority. Number 4, the judicial remedy and ADR is very important. The judges, need to take a responsibility in shaping good corporate governance. Number 5, media is important. It's about social media. The traditional media has lost their, past glory. Number 6, public investors and stakeholders need to be, more active. And I think the public interest litigation or class action will be very helpful in this regard, and punitive damage could be helped. Last but not the least, the independent academic evaluation is very important. Like the emperor's new clothes, I think this boy, is really, very, very respectable. Thank you very much. Any questions or comments? Yeah. Okay, great.
Thank you, Professor Liu. Thank you so much for this provoking presentation. And my question is primarily focusing on the division of labor or division of cooperations between the soft law and the hard law. For example, to say in a very briefly and very simple way, who should take the lead, in your opinion, in terms of shareholder protection in China? For example, in the Vanke case, where people are struggling as to which kind of position they should take, because the deal between Vanke and Shenzhen Metro is actually only memo. It's not the final term, and the details of the term has not been decided yet. It's only an intentional managerial move forward in the coming few years. So whether this deal should be taken to the shareholder meetings at this stage is quite controversial. And if you use hard law to regulate this kind of action, you still face the issue as to what extent hard law or soft law could regulate commercial behaviors. And I want to seek your opinions on this issue. Thank you.
Oh, very good question. I still prefer, the soft law as a primary solution. For example, the core value of the management is very important. Actually, Mr. Wang maybe made a mistake. Actually, China has not took the same position as the U.S. The shareholder primacy or shareholder, not the board centralism. We still adhere to the traditional shareholder primacy or shareholder sovereignty. So I think the informal memo, of course, important, but you have to go through the board directors before the board decisions is approved by the general meeting of shareholders, because this, information was already released in the market. So I don't think Mr. Wang could think, okay, the shareholders could be replaced, by another important strategic partner. I think so. The core value, the best practice, or good governance policy on the part of companies are very important, and the key people are the management, the insider, Mr. Wang. In China, many managers believe they are the real number one person in the company, but I think they're only servant. They should serve the best interests of their masters. And also, regarding the division of the soft law, hard law, as I said, we have two different perspectives. One simple perspective is that if certain social norms or rules made by the legislature, the government, or by the court, that's hard law. Any other rules, made by the company itself or by the Chamber of Commerce are soft law. But another perspective is focused on the nature of the substance of the rules. If the rules are protected by the legal liabilities, we call it the hard law. If it's not protected by the legal liabilities, that's only some permissive policy. We could classify it as a soft law. Thank you very much. Yeah, Dan.
Thank you, Junai. Really, once again, a very interesting presentation, revealing some things that the 7 steps in particular. I thought that was very, very interesting. Robin Huang this morning pointed out that there's no real definition of CSR at the moment, so that leads to some sort of a vagueness. You also said that some of the information contained in some of these CSR reports are not reliable. So the question is, I'm not only referring to China, but generally, what is the answer to make sure that we get the correct information? Should we really regulate this in a hard way, or should we concentrate on CSR rating agencies, which could be regulated? So you regulate the agency and you make sure that they report and they rate all companies as to how good they are on their CSR reports. Could that be a solution to get the market to get the right type of information on CSR?
I totally agree with you. We think we should, encourage the rating agencies play the active role in respecting the public right to information. However, when we look back at the history of the rating agencies, especially of the derivative financial products, or even the performance of the accounting firms, we are not satisfied with this kind of third-party rating because they are paid by the company. So, the rating agency people and other intermediate people told me that, Professor Liu, the company is my client, so it's the God. I could not obey the will of the God. So we need to reorient the role of the rating agency. Who's your master? Who's your beneficiary? Who's the principal? So whose agent? You should make it very clear. So I think the rating agency should be reoriented as agent of the public, especially non-shareholder constituencies, but not the company to be rated. And I think that is very important. So I would like to introduce that rule into the future law on CSR, that hard law. The relationship, the agency relationship could not be abused. For course, for some technical reasons, the legislature should also formulate some uniform, comparable, and feasible formulating methodologies for the companies to disclose their corporate social responsibility information. So thank you.
All right. Thank you very much for that long
Okay,
presentation.
so it's time for me to receive your gift? Wonderful, yeah. I have been dreaming of to get the gift from yesterday. Yeah. Thank you very much. Yeah, okay. Picture.